Hi, I'm Tom Bradford. I'm a lawyer and barrister, and in this video I'm going to explain how you can prepare your grounds of appeal against the refusal of an immigration application for the UK. Now, when bringing an appeal as a non-EEA national, so non-European national, you should be aware that there are only limited grounds on which you can bring an appeal. First of all, in order to even have a right of appeal to the tribunal, you need to have received a certain kind of decision. Even if it's a business visa application, to be able to appeal, it must have included a refusal of a human rights claim. Protection claims and revocation of protection claims also qualify. If your refusal is not one of these kinds, then you will need to apply for administrative review or judicial review. I have separate video guides coming out on these shortly. Now, often, even in a business immigration matter, if there's a family life element to it, then it's sensible to include a human rights claim in order to trigger a right of appeal upon refusal. This is because administrative reviews and judicial reviews are very limited in nature. What I want to explain in this video is that the grounds of appeal you can actually bring within an appeal are very wide, notwithstanding the government's attempt to curtail them in legislation. So the position in law is, if you're appealing, is set out in Section 82 of the Nationality, Immigration and Asylum Act 2002. The government's restriction of rights of appeal is set out in statute in Section 84(3) of the Nationality, Immigration and Asylum Act 2002. This says, as relevant, that the appeal must be brought on one or more of the following grounds. And for our purposes, this is that removal of the appellant from the United Kingdom would be unlawful under Section 6 of the Human Rights Act 1998. And that relates to a public authority not being able to act contrary to the Human Rights Convention. The important thing for you to bear in mind here is that the human rights element of the claim contains the ability to then bring broader challenges. So firstly, there is an issue of what a human rights claim is. You will generally need to have added some substance to a human rights claim in your application in order for it to be triggered. I encounter this issue in a business immigration context, at least, where the human rights element of the claim may not have always been expressed in explicit form. But if you can bring your appeal on this basis, you can have your challenge considered by an immigration judge rather than a Home Office official, as would be the case in an administrative review. And there are many other legal provisions which you can then rely on in your grounds of appeal. As I say, I'm coming to that point in a moment. So although the UK government has severely restricted rights of appeal and replaced them with administrative review, there are still a broad range of challenges your refusal decision can then trigger when you bring your grounds of appeal, and you need to be able to argue that your decision amounted to refusal of a human rights claim. As I say, if you haven't actually brought a human rights claim, or actual or implied, then this will not be available. But once we have a human rights claim, then Section 6 of the Human Rights Act 1998 says that it's unlawful for a public authority to act in a way which is incompatible with a convention right. And then Article 8 states that everyone has the right to respect for his private and family life, his home and correspondence. And crucially, there shall be no interference by a public authority with the exercise of this right, except as in accordance with the law. Now, this point, in accordance with the law, really opens matters up, because as long as you can show there was interference with private or family life as a result of the decision, any other basis in law on which it could be said that the decision was unlawful can also be relied on in your grounds of appeal. This is as broad as it could possibly be. So you can rely on a ground which states that the decision was not in accordance with the immigration rules, that the decision maker failed to exercise discretion in a way that was consistent with the relevant guidance, and, for example, very importantly, where the rights of children are engaged, you can rely on Section 55 of the Borders, Citizenship and Immigration Act 2009. This states that the Secretary of State must make arrangements for ensuring that certain functions are carried out, having the regard of the needs to safeguard and promote the welfare of children who are in the United Kingdom. Children just means persons. It's defined as persons who are under the age of 18. And the functions in question include immigration matters. So this places an obligation on any person exercising any of those immigration functions to have regard to the guidance given by the Secretary of State. Broadly, the position in law is that the child's best interests rank as high as immigration control. But often one comes across decisions in which the children's rights have not been taken into account at all. So this can be a really powerful ground where it applies, a ground of appeal. The main point, though, is that you should not come away believing that the right of appeal is so narrow that it means you're restricted in what you can submit in your grounds. As I say, the effect of Article 8 is that once you can argue that your private or family rights are engaged, you can bring challenges within your grounds on the basis of alleged unlawfulness, referencing provisions beyond the Human Rights Act. Lastly, do remember that if you are in the UK, then your appeal must be lodged with the tribunal within 14 calendar days of the date that you were sent the notice of decision. If you are outside of the UK, then you must appeal within 28 calendar days of the date that you received the entry clearance decision. So if you need help with an appeal, do let me know. Just drop me an email and we can arrange a consultation. I hope you found this helpful. I am producing more on this topic, so do feel free to subscribe and click the notification bell to get my future updates on appeals and other ways of challenging refusals. Thanks, and see you in the next video.